To begin with, we have one question from Anthony who asks, was there always intense politicizing of the Supreme Court whenever the amount of justices were changed?
The court starts off with 6 people, and over time it grows to 9. During the Civil War, a 10th was added in part because there was concern about how the court would rule on the legal tender cases. It's dropped back down to 9. Roosevelt obviously suggested to go up as high as 15. There was massive public pushback against that because Roberts and Hughes changed their votes. That part of the court pact plan went nowhere. And really, it hasn't come back until very recently, in part because of the appointments of Gorsuch replacing Scalia. Scalia died when Obama was president, but the Republicans, Mitch McConnell, who controlled the Senate at that time, refused to bring up Merrick Garland, Obama's nominee, to replace Scalia until after the election. And then Trump wins, he appoints Gorsuch. Then you have the Kavanaugh appointment, which is sort of a normal appointment in the sense that it happened in the middle of the president's term. And then you have Ginsburg dying just before the election in 2000. And McConnell and the Republicans getting Coney Barrett confirmed very quickly, just so they wouldn't have to worry about the next president, if it wasn't President Trump, making the nomination. So again, go back to the very beginning. Marshall goes to the Supreme Court because Adams wants to have Federalists on the Supreme Court, because that's the only place the Federalists are going to be able to control after the Revolution of 1800. Judicial nominations, especially in times of high constitutional conflict, have often been tainted is the wrong word, but have often been impacted or affected by political concerns. There's nothing new there.
Does that answer your question, Anthony? Cool. All right, next one we have, has the government ever been close to limiting Supreme Court term limits?
There have been proposals over time to impose term limits. Those likely would have to come through constitutional amendments, since the Constitution says judges will serve for good behavior. That's a pretty high hurdle to jump. But those conversations have occurred from time to time. There have been conversations about limiting the jurisdiction, the appellate jurisdiction of the Supreme Court, the kinds of cases the Supreme Court can accept, hear, and decide. A notable example would be taking jurisdiction away from the Supreme Court, appellate jurisdiction on questions involving abortion, for example. Just say federal courts don't have jurisdiction over matters of abortion. That has come up occasionally. Usually these things sort of die out. And it will be interesting to see. President Biden has a commission looking into this. The commission, from recent news reports, is split between whether or not to endorse expanding the size of the court, more consensus on bringing in term limits. These things tend to arise, and they tend to arise when the court seems to be either out of sync with the nation politically, or very prominent in constitutional issues, which are really political issues as well.
All right, next question. Besides tribalization / political parties, what other obstacles do you see that threaten each branch's responsibility to jealously guard their power?
Well, Madison in Federalist 51, and this is one of these great essay questions for a comprehensive essay in an Intro to American Government course in college. Madison said, ambition would counteract ambition. The interests of the man would protect the constitutional rights of the place. And in fact, what you see here is instances where Congress may sort of threaten the court by passing legislation, either overturning court decisions if those decisions were statutory in nature. And that's been done in the past. Possible threats to add to the Supreme Court, to change its jurisdiction. And the justices are aware of these things, right? They don't live in a bubble. They live in Maryland, DC, or Virginia for the most part. And that may work to temper some of their decisions as well, sort of an informal institutional check, not trying to go too far. Presidents obviously can check the court in terms of their enforcement of its decisions. And also through the power to nominate and hopefully get confirmed from their perspective justices to the court. So this plays out. What you've seen over the course of American history is that the power of each of these branches has grown. And we'll talk a little bit about that when we talk about the documents. The power of each of these branches has grown over time. Judicial power has grown with the assertion of judicial review in Marbury, and legislative power has grown. McCullough is a good example of that. Presidential power has grown as well. So each of the branches' power, net power, has grown. Their capacity to check each other thus is still in place. It just varies from time to time, which sort of pushes the upper hand.
We've got a convo going in the chat, kind of building on similar questions about states challenging federal authority, citing the executive orders from the governor of Texas. How will this play out or even reach the court? Also, what do you make of the current nullification by the states, mostly Texas, of some landmark cases like Roe v. Wade, no more cooperative federalism? Does it endanger the Constitution's supremacy if the states can use the polarization of the court to ignore set law?
That's a lot. Let's just start with the supremacy of the Constitution. From the perspective of those who oppose the abortion right is constitutionally illegitimate. It's not in the Constitution. And so Roe v. Wade, Planned Parenthood v. Casey, all the abortion cases which have upheld a woman's right to terminate a pregnancy are unconstitutional. And this is an assertion, and this is one of those things, the wheel of federalism and the wheel of separation of powers keeps turning. This is an assertion of states' rights and states' authority that is in some ways evocative of state blowback against desegregation, Brown v. Board of Education. The argument being made that the Supreme Court was wrong and that ultimately the states get to decide what powers the national government has and what the Constitution means. The Texas abortion statute has been appealed to the Supreme Court by the Biden administration, I think today, or maybe at the tail end of last week. So they are seeking the Supreme Court's judgment as to whether or not this legislation should be stayed, pending judicial resolution of whether or not Texas has that power. This is, again, one of the reasons why I flooded the picture of those justices at the end of this presentation. There are currently 6 justices on the Supreme Court appointed by presidents who were profoundly pro-life. Okay. Now, in the past, that didn't necessarily mean they opposed the abortion right. And in fact, the abortion right was saved in 1992 by 3 Republican appointees, Souter, O'Connor, and Kennedy. But the last batch of appointees, really beginning with Alito, Roberts is probably the weak link in that coalition's chain. But beginning with Alito, these appointees have been very closely vetted on those issues most significant to the political coalition that produced the president and the Congress, the Senate that confirmed them. So it will be interesting to see, and the Texas case is a really intriguing one, how the court splits and whether or not they allow or reimpose the stay that had been imposed by the district court judge on the operation of the Texas abortion statute. That will tell you a lot about their concept of state authority vis-a-vis federal authority. I think that answered at least part of that